Please be seated. Good morning. The sitting is now open. The court meets this morning to hear the oral statements of the United States of America, the Russian Federation, France, Hungary, and Indonesia. Each of the delegation has 30 minutes at its disposal for its presentation. The court will observe a short coffee break after the presentation of France. I shall now give the floor to Mr. Josh Simmons, speaking on behalf of the United States of America. Sir, you have the floor.
Good morning, and thank you, Mr. President, Madam Vice President, and members of the court. It is an honor to appear before you today on behalf of the United States of America. The ongoing conflict in Gaza is a critical issue for the international community. This week, many speakers have focused on the factual circumstances of that conflict. They have voiced significant concerns about the flow of humanitarian assistance into Gaza. You have also heard concerns about Israel's decision to cease engagement with UNRWA. You have heard little, however, about the serious, incredible concerns about Hamas misusing UNRWA's facilities and humanitarian assistance. You have also heard little of Israel's security needs after the terrorist attacks on October 7th, 2023. These security needs persist today. Many hostages, including Americans, are still being wrongfully held in horrendous conditions. These are grave circumstances, and they warrant careful attention. But the General Assembly's expedited request, and therefore this advisory proceeding, focuses solely on a request to identify legal obligations. It is not about adjudicating the facts or determining legal consequences. The United States submits that what is before the court is a legal question consisting of two narrow legal issues, and that the answers are clear under well-established rules of international law. These answers would apply regardless of the particular state under consideration. The first issue focuses on the obligations of an occupying power, and the second focuses on the obligations of a UN member state. Mr. President, members of the court, allow me to first address the obligations of an occupying power to the United Nations, international organizations, and third states with respect to humanitarian assistance. International law does not impose any unqualified obligations on an occupying power regarding all these entities, much less any particular entity. The applicable international rules have been carefully developed through state consent to treaties and customary international law. As the court repeatedly recognized, international humanitarian law is the lex specialis governing the obligation of parties to armed conflict. Within that lex specialis, it is the law of occupation that establishes an occupying power's specific rights and obligations. Before diving into the particular obligations of any occupying power, we should step back to understand the context for why states have agreed to specific rights and duties in occupation law. As the court has previously observed, occupation is a question of fact, and occupation law describes the rights and responsibilities for administering control over occupied territory. An occupying power has obligations related to maintaining public order and safety and protecting the civilian population. It also has the right, while an occupier, to pursue its military objectives and govern enemy territory. In the law of occupation, therefore, military and humanitarian interest converge. This means that where specific provisions of that law call on an occupying power to provide the civilian population with relief, the occupying power does not lose its right to ensure its own security. With this framing in mind, I will address the specific limited obligations of an occupying power toward third states and organizations in two categories. First, obligations on allowing and facilitating relief for the civilian population, and second, rules relating to the impartiality of humanitarian organizations. In both categories, occupation law preserves an occupying power's discretion to address its security interest, including the ability to curtail the activities of third states or organizations that are contrary to its security. For the first category, most submissions to the court address the Fourth Geneva Convention of 1949. Article 59 of the Fourth Geneva Convention states that when the population of the occupied territory, quote, is inadequately supplied, the occupying power shall agree to relief schemes on behalf of the said population and shall facilitate them by all the means at its disposal. Several submissions incorrectly assert that this means that Article 59 requires an occupying power to agree to all relief offered by all outside organizations. But the text of Article 59 contains no such expansive language, nor does it prescribe which relief schemes an occupying power must consent to. The only mention of third parties comes in the next paragraph of Article 59, which states, quote, such schemes, which may be undertaken either by states or by impartial humanitarian organizations, such as the International Committee of the Red Cross, shall consist in particular of the provision of consignments of foodstuffs, medical supplies, and clothing, end quote. The word impartial is obviously important, and I will return to it. But for now, focus on the fact that this provision is actually a definition of what a relief scheme provides. That is, food, medical supplies, and clothing. The language on third parties merely describes possible providers of relief, which is clear from the words may and such as before the example of the International Committee of the Red Cross. It is also critically important that Article 59 does not remove an occupying power's authority to ensure public order and safety in the territory. In other words, an occupying power retains a margin of appreciation concerning which relief schemes to permit. Thus, even if an organization offering relief is an impartial humanitarian organization, and even if it is a major actor, occupation law does not require an occupying power to allow and facilitate that specific actor's relief operations. An occupying power may also fulfill its humanitarian obligations toward the civilian population while advancing its own military and security interest. An example can be found in Article 55 of the Fourth Geneva Convention. Article 55 describes the obligation of an occupying power to ensure the food and medical supplies of the population. But as the ICRC commentary explains, under Article 55, quote, the occupying authorities retain complete freedom of action in regard to this, and are thus in a position to take the circumstances of the moment into account, end quote. Similarly, while Article 63 recognizes that national Red Cross societies and other relief societies are permitted to continue their humanitarian work under Red Cross principles, an occupying power may still impose restrictive measures for urgent reasons of security. I turn now to the second category, which is a fundamentally important limitation built into occupation law. Articles 59 and 61 of the Fourth Geneva Convention make clear that collective relief may be conducted by third states or, quote, impartial humanitarian organizations. As many submissions acknowledge, impartiality requires that humanitarian relief be distributed in a non-discriminatory manner. However, the concept of impartiality in the phrase impartial humanitarian organization also refers to taking no side in the armed conflict. The ICRC commentary to Article 59 makes this clear. It says that, quote, only those states which are neutral are capable of providing the essential guarantees of impartiality, end quote. And the commentary to Article 61 shows that the term impartiality in describing organizations providing relief is synonymous with neutrality. Here, there are serious concerns about UNRWA's impartiality, including information that Hamas has used UNRWA facilities and that UNRWA staff participated in the October 7th terrorist attack against Israel. Israel, therefore, has ample grounds to question UNRWA's impartiality. Some have argued that the evidence is insufficient, or that the UN's investigation and the Kelowna report have resolved concerns about UNRWA. But the Kelowna report itself recognizes that, quote, neutrality-related issues persist for UNRWA, and that there continue to be serious challenges with respect to UNRWA's oversight and accountability. Again, the court need not and should not reach these factual issues. But given these concerns, it is clear that Israel has no obligation to permit UNRWA specifically to provide humanitarian assistance. UNRWA is not the only option for providing humanitarian assistance in Gaza. In sum, there is no legal requirement that an occupying power permit a specific third state or international organization to conduct activities in occupied territory that would compromise its security interests. To hold otherwise would be contrary to the Fourth Geneva Convention. Mr. President, members of the court, I turn now to the obligations of Israel as a UN member state. The Security Council and General Assembly have worked for decades toward an end to the conflict between Israel and the Palestinians. Throughout that long history, Israel has hosted and engaged with the UN, UN agencies, and UN representatives. Some participants have argued that this engagement has resulted in or arisen out of additional obligations on Israel solely by virtue of Israel's membership in the United Nations. Those arguments rest on mischaracterizations of the UN Charter. The General Assembly does not have the power to impose on Israel a perpetual obligation to cooperate with UNRWA. This is a fundamental principle that is distinct from any obligations Israel or any UN member state might have toward a UN entity that it agrees to host. This is because the UN Charter codifies an allocation of power and responsibilities among its principal organs, particularly between the Security Council and the General Assembly. That allocation was deliberately chosen by the drafters and is central to the United Nations approach to advancing international peace and security. This court's prior opinions, both in competence of the General Assembly and in certain expenses of the United Nations, remind us that in interpreting the Charter, the court considers the relationship that the Charter establishes between the General Assembly and the Security Council. This structure has paramount importance. Yet many arguments in these proceedings would upset this structure, including the suggestion that Article 2, Paragraph 5 of the Charter effectively confers upon the General Assembly powers reserved in the Charter for the Security Council. That is incorrect. Article 2.5 states in relevant part that, quote, all members shall give the United Nations every assistance in any action it takes in accordance with the present Charter. This clause does not mean that resolutions by the General Assembly form binding obligations on member states. The Charter carefully defines the responsibilities that are unique to the Security Council. Under Article 39, only the Security Council can decide what measures, quote, shall be taken by UN member states to maintain or restore international peace and security. And only the Security Council can make the threat determination that must precede such binding decisions. In addition, such decisions require not only that at least 9 Security Council members vote yes, but also that the 5 permanent members either vote yes or abstain. Unlike the Security Council, the recommendations and activities of other UN organs, including the General Assembly, do not themselves have authority to bind UN member states. The Charter is clear as to the limits of the General Assembly's powers. Under Article 10, the General Assembly may make recommendations to the members of the United Nations. And under Article 14, the General Assembly, quote, may recommend measures for the peaceful adjustment of any situation, end quote. In sum, while the General Assembly may make recommendations, it may not order coercive action. Straining international law to expand the General Assembly's powers, as some have suggested here, would serve only to weaken the foundations of international law. This court has also recognized the Security Council's unique role under the UN Charter. For example, in the certain expenses case, the court explained that, quote, it is the Security Council which is given a power to impose an explicit obligation of compliance, and, quote, it is only the Security Council which can require enforcement by coercive action, end quote. And the court itself has interpreted action to mean coercive or enforcement actions, as in Article 11, Paragraph 2 of the UN Charter. While the court also indicated that measures recommended by the General Assembly under Article 14 implies some kind of action, it did not do so in the context of determining the scope of Article 2.5. Some suggest that Article 2.5 is not limited to enforcement actions by the Security Council, but they do not account for the fact that the Charter does not use the word action in describing the General Assembly's powers to make recommendations on questions relating to the maintenance of international peace and security. Nor do they account for the negotiating history of this article, which is explained in the United States written submission. The attempt to expand Article 2.5's meaning would also be contrary to the practice of the United Nations with respect to other entities that the General Assembly has created. The court emphasized this in the certain expenses case when it pointed to the UN Secretary-General's statement that, quote, while the General Assembly is enabled to establish force with the consent of those parties which contribute units to the force, it could not request the force to be stationed or operate on the territory of a given country without the consent of the government of that country. Some have pointed to what they consider to be precedents in arguing for a wider role for the General Assembly, but these are easily distinguishable. The situation here is not parallel to Namibia, where the UN General Assembly acted in conjunction with binding UN Security Council resolutions. Nor does the question before the court involve the responsibilities assigned to the General Assembly, which the court considered in certain expenses. There, the court found that the General Assembly had the power to take decisions to approve the budget of the organization. That case is clearly distinct because the General Assembly was acting under express authorization in the UN Charter to make certain decisions on budgetary matters. The reparations case stands for nothing different. In that case, this court affirmed that the United Nations is an international organization imbued with the powers essential to the discharge of its functions, including the capacity to claim appropriate reparation for damages suffered. The case has been repeatedly cited by the court for that limited proposition. And while the court referred to the importance of Article 2.5 to the effective functioning of the UN, the court expressed no opinion or analysis as to the scope of obligations incurred by the member states under that article. In the reparations case, the Charter was silent on the issue before the court. Yet here, the Charter is clear that the General Assembly lacks the power to impose binding obligations on UN member states. Other participants suggest that the court should interpret Article 2.5 expansively by reference to other articles in the Charter, the principle of good faith or the duty to cooperate. The United States respectfully submits that the court should reject the proposition that Article 2.5 transforms the recommendations of the General Assembly into binding obligations. The obligations under the UN Charter must be implemented in good faith, but good faith does not obligate a UN member state to take specific measures in the absence of a decision by the Security Council that particular action is necessary. In this case, the Security Council has not adopted a binding resolution that Israel must cooperate specifically with UNRWA. Absent such a Security Council decision, individual member states have flexibility to determine appropriate measures consistent with applicable law. They can give due consideration to the recommendations of UN organs, but such recommendations plainly are not binding. The court should also decline to find that a general purpose of the United Nations, such as under Article 1.3 of the Charter, may impose a specific legal obligation on a UN member state. As the court made clear in the certain expenses case, it is necessary to distinguish between the purposes of the United Nations and the powers conferred to effectuate those purposes. These powers are not unlimited. Nor should the court reinterpret Article 2.5 on the basis of Articles 55 or 56 of the Charter. Article 55 provides objectives for the United Nations to promote. Article 56 then provides for a generalized commitment to cooperate with the United Nations in pursuit of the objectives in Article 55. Neither of these articles compels, much less lists, particular actions for the organization or its member states to undertake. These articles were not intended to infringe upon member states' authority to determine how to advance these objectives of the United Nations. Mr. President, members of the court, before I conclude, I would like to make three overarching observations about the question referred to the court in this advisory proceeding. First, it cannot escape notice that the request follows the regrettable precedent of seeking advice with respect to the obligations of only one of the parties to the underlying conflict. We are all well aware that less than a year ago, the court provided its advice on a broad set of questions focused one-sidedly on Israel and its activities. Second, the General Assembly has simply asked the court to identify the obligations of Israel. The narrow framing of the question is important because the court has related contentious proceedings before it, including with Israel as a party. This means that, consistent with the narrow scope of the question, there should be no finding either as to compliance with any obligations identified in this proceeding or as to the legal consequences of any alleged breach. Third, the question is limited to identifying those obligations in relation to the presence and activities of the United Nations, other international organizations, and third states. While there certainly are rules of international law relevant to the population of an occupied territory, those were addressed in the court's July 2024 opinion and do not need to be revisited. Similarly, the court has recently advised on the right to self-determination in this context. The question before it here does not require revisiting the analysis of that right. In concluding my remarks, let's return to the principles I began with. The question before the court in this proceeding is, by definition, a legal question. The General Assembly has asked the court to identify a set of obligations, and that is all. We also urge the court to bear in mind that the rules applicable in this context apply globally and to all states. Some have asked you to identify sui generis responsibilities for Israel, or even a sui generis responsibility tied to UNRWA. Identification of such novel obligations would be inconsistent with international law, including the UN Charter. Novel legal interpretations will not bring an end to the ongoing conflict. They will not bring the hostages home. They will not create a better tomorrow for Israelis, Palestinians, and the region. To be clear, the United States supports the flow of humanitarian aid into Gaza, with the safeguards to ensure it is not looted or misused by terrorist groups. We encourage the international community to focus on advancing a ceasefire and on fresh thinking for a better future for Israelis and Palestinians alike. Mr. President, members of the court, this concludes the oral statement of the United States. Thank you for your attention.
I thank the representative of the United States of America for his presentation. I now invite the next participating delegation, the Russian Federation, to take the floor. And I call Mr. Maxim Mishkin to the podium. You have the floor, sir.
Mr. President, Madam Vice President, members of the court, it is an honor to address the court, the principal judicial organ of the United Nations, on behalf of the Russian Federation. Today, we confront a crisis of legality and humanity in light of systematic undermining of the United Nations Relief and Works Agency for Palestine refugees by Israel and its negligence towards the overall obligations under international law, including those stemming from the status of Israel as an occupying power. The urgency of this matter cannot be overstated. Gaza balances on the brink of famine, hospitals lie in ruins, millions of Palestinians in the Strip, as well as in the West Bank, including East Jerusalem, face existential despair. Mr. President, the General Assembly's request for an advisory opinion, adopted by 137 states in Resolution 79-232, is based on Article 96 of the UN Charter and Article 65 of the ICJ statute. These articles provide for the advisory jurisdiction of the court. Some states, including Israel, in their written statements have argued that this request is politically charged, concerns bilateral relations, and the subject of the ongoing proceedings between South Africa and Israel on application of the Genocide Convention. This is not the first time the court considers the relevant aspects of the conflict between Israel and Palestine. The court's 2004 Wall Advisory Opinion and 2024 Opinion on the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem, established irrefutable precedents. In 2004, the court affirmed that Israel's construction of the wall violated international humanitarian law. In 2024, it reaffirmed Israel's status as an occupying power in the Palestinian territory. including the Gaza Strip. These opinions constitute a solid foundation for facilitating peace in the region and ensuring the rights of Palestinians to self-determination, as well as providing for legal qualification of Israeli actions. They also serve as a basis for the present request of the United Nations General Assembly. Today, we address a new dimension: Israel's October 2024 laws banning UNRWA's operations, which, in our view, directly contravene the norms of IHL, the UN Charter, and the 1946 Convention on the Privileges and Immunities of the United Nations. Under Article 30 of the latter, disputes over its interpretation must be referred to this court. Thus, the Russian Federation invites the court to follow its own reasoning on jurisdiction and discretion to hear the present case used in 2024 advisory opinion, since the factual and legal background of these cases are quite similar. Besides, the question put before this court is strictly legal. It concerns Israel's duties as an occupying power under IHL and its obligations to uphold the privileges and immunities of the UN agencies, other international organizations, and third states in and in relation to the occupied Palestinian territory. Therefore, we maintain that judicial restraint here would undermine the very architecture of international law. Mr. President, to understand the importance of this moment, we must reflect on history. Established in 1949 by General Assembly Resolution 302, UNRWA was created to address the catastrophic displacement of 750,000 Palestinians. Today, it serves 5.9 million Palestinian refugees across Gaza and West Bank, Jordan, Lebanon, and Syria. For 75 years, UNRWA has been more than just an aid agency. It is a symbol of international community's collective responsibility to the Palestinian people, striving for a state of their own, in exercise of their right to self-determination, in accordance with international law, and return. The role of UNRWA in facilitating the humanitarian aid is crucial, and its work is strongly supported by the vast majority of the international community. The agency's mandate, education, healthcare, and emergency relief is not mere charity. These spheres are legal obligations of the occupying power under IHL. When Israel occupied Gaza and the West Bank in 1967, it inherited the duty to ensure the welfare of the population on the occupied territory. Instead, this responsibility was outsourced to UNRWA and other UN agencies and programs, relying on the agency's schools, clinics, and distribution networks to mitigate the humanitarian impact of Israel's own policies. In Gaza, as mentioned in the United Nations Security Council press statement of the 30th October 2024, UNRWA remains the backbone of all humanitarian response, and no organization can replace or substitute UNRWA's capacity and mandate to serve Palestinian refugees and civilians in urgent need of life-saving humanitarian assistance. Now, with the resumption of Israel's military operation in Gaza, together with the imposition of a total blockade since the 2nd of March, the Strip has continued to endure devastating destruction and a humanitarian catastrophe of unprecedented scale. The West Bank, where Israel has launched its full-scale military operation on the 21st January, risks repeating terrible Gaza scenario. UNRWA's installations and personnel are under attack there too, as well as in East Jerusalem, where after the enactment of the Knesset bills on the cessation of UNRWA's operations, all the offices, including the historic premises Sheikh Jarrah and Kalandia, operated since 1950, were arbitrarily closed. By doing so, Israel, for the first time in history, unilaterally prohibited the work of the United Nations Agency and deprived it of its privileges and immunities. It is also worth mentioning here that this year UNRWA has been again nominated for the Nobel Peace Prize. Awarding this prize will obviously be timely and well deserved, taking into account the highest price the agency has paid during the recent crisis in the Middle East. Israeli military operations claimed lives of 290 of UNRWA's staff members. To this effect, Russia has been consistently advocating for an unconditional and sustainable ceasefire, the release of all hostages and detainees, safe and unhindered humanitarian access, as well as the restart of the peace process on a universally recognized international legal basis with two-state solution formula at the center. Mr. President, it is the position of the Russian Federation, which is based entirely on the advisory opinions of the Court of 2004 and 2024, that Israel, as the occupying power, is bound by the IHL, including the Fourth Geneva Convention and the Hague Regulations. The Court observed in the Wall advisory opinion that in the 1967 armed conflict, Israel occupied the territory between the so-called Green Line and the former eastern boundary of Palestine under the British mandate, namely the West Bank and East Jerusalem. The situation since then has not improved, but rather deteriorated. According to the 2024 advisory opinion, Israel's withdrawal from Gaza Strip has not entirely released it of its obligations under the law of occupation. Therefore, Israel, to this day, remains an occupying power in terms of IHL, and its relevant rules and principles are fully applicable to Israel. We consider the following provisions of IHL as especially pertinent to the case in hand. Under Article 43 of the Hague Regulations, and I quote, "The occupant shall take all the measures in his power to restore, to ensure as far as possible public order and safety." End of quote. Under the Court's interpretation in the opinion of 2024, this includes the duty to administer the territory for the benefit of the local population. Article 50, paragraph 1 of the Fourth Geneva Convention provides that the occupying power shall, with the cooperation of the national and local authorities, facilitate the proper working of all institutions devoted to the care and education of children. Article 55, paragraph 1 of the Fourth Geneva Convention further provides that, and I quote, "To the fullest extent of the means available to it, the occupying power has the duty of ensuring the food and medical supplies of the population. It should, in particular, bring in the necessary foodstuffs, medical stores, and other articles if the resources of the occupied territory are inadequate." End of quote. Article 56, paragraph 1 of the Fourth Geneva Convention provides that, and I quote, "The occupying power has the duty of ensuring and maintaining the medical and hospital establishments and services, public health, hygiene in the occupied territory." End of quote. Article 51 obliges Israel to facilitate humanitarian relief schemes by all the means at its disposal, if the whole or part of the population of an occupied territory is inadequately supplied. None of that is happening today. As stated in the UN Secretary General's press encounter on Gaza of the 8th of April 2025. Israel and its supporting states claim that other agencies can replace UNRWA, and the occupying power has discretion to determine whether, when, and to what extent other parties may be present and operate in the occupied Palestinian territory. We respectfully ask the Court not to follow this line of logic. Firstly, no organization possesses UNRWA's infrastructure in the Gaza Strip and the West Bank. 65 clinics, 12 food distribution centers in Gaza, and 30,000 local staff. Without UNRWA, Gaza's humanitarian system will collapse. And secondly, the mentioned before Article 59 of the Fourth Geneva Convention unequivocally obliges the occupying state to agree to the relief schemes on behalf of the said population. The Fourth Geneva Convention not only lays down that the occupying power must agree to the said relief schemes, but insists that it must facilitate them by all the means at its disposal. The occupation authorities must therefore cooperate wholeheartedly in the rapid and scrupulous execution of these schemes. Israel claims its laws on UNRWA are necessary for national security. Israel has the right to ensure its own security. But the path to this goal lies exclusively through a comprehensive Middle East settlement process and the realization of the legitimate right of Palestinians to their own state within the borders of 1967, with East Jerusalem as its capital. The right derives from one of the fundamental principles of the United Nations Charter, the right to self-determination of peoples. Even so, the security concerns do not absolve Israel from other norms of international law, including the norms of on privileges and immunities of international organizations. Furthermore, the Fourth Geneva Convention in its Article 59 provides for safeguards that the relief consignments may be searched by the occupying power. UNRWA has cooperated with the Israeli authorities for decades, sharing staff lists, facilitating aid coordination, and conducting a thorough audit, the results of which are available to the public. We maintain that security issues should be subject to substantive cooperation and discussions between Israel and UNRWA to mitigate these concerns. Since the laws on the cessation of UNRWA operations also prohibit all contacts between Israel's government and UNRWA, the much-needed negotiations are stalled on the part of Israel. Given the crucial role UNRWA has played in over 75 years of its activities in the region on behalf of the Palestinians, the cessation of its operations will result in the catastrophic scarcity of supplies and assistance to population of the occupied Palestinian territory, including refugees in the neighboring countries, Jordan, Lebanon, and Syria. Israel's laws on the prohibition of the work of UNRWA will undoubtedly worsen the humanitarian situation in the occupied Palestinian territory and will make the population in the said territory inadequately supplied, the language used in Article 59 of the Fourth Geneva Convention. The role of the agency in providing complex assistance to the Palestinians is crucial to ensure their fundamental rights, including the cornerstone UN Charter right to self-determination within the two-state solution framework. Mr. President, turning to the issues of privileges and immunities, The Russian Federation submits that UNRWA's legal status is clear. As a subsidiary organ of the General Assembly under Article 22 of the UN Charter, with a clear humanitarian mandate, it is entitled to privileges and immunities under the 1946 Convention. Furthermore, according to Article 105 of the United Nations Charter, the organization shall enjoy in the territory of each of its members such privileges and immunities as are necessary for the fulfillment of its purposes. Israel's October 2024 laws revoking UNRWA's immunities, criminalizing its staff, and seizing its assets constitute a violation of this framework. In no way do the provisions of the UN Convention of 1946 allow the unilateral revocation of privileges and immunities. The privileges and immunities of the United Nations play an important role in ensuring the functioning of this organization. They are necessary to fulfill the basic functions of the United Nations, such as maintaining peace and security, promoting international cooperation, and protecting human rights. Privileges and immunities allow the United Nations to carry out its activities freely, without fear of persecution by states or individuals. This ensures the independence and impartiality of the organization in carrying out its tasks. Israel's legislation is not merely unlawful, it is an attack on the UN fundamental principles. If tolerated, it sets a very dangerous precedent for states to dismantle any UN agency they deem inconvenient. Within the broader context of Arab-Israeli conflict, it is necessary to highlight that other UN structures, UNFIL and UNDOF in Lebanon and Syria, have also been negatively affected and obstructed by Israeli invasions and continued unlawful military presence. In a more broad context, United Nations admissions of states to the UN were also impacted. There were numerous violations by Biden and Obama administrations of the agreement regarding the headquarters of the United Nations of 1977 and the UN Convention of 1946. Part of the official premises of the Russian mission in the United Nations in New York was blocked. Issuance of visas of the state representatives for meetings under the auspices of the United Nations and of the UN staff members of specific nationality was deliberately hindered. Movement restrictions were put into effect. Similar violations regarding issuance of visas are committed by France as the host country of UNESCO. The erosion of privileges and immunities strikes at the heart of multilateralism, undermining the UN's capacities. Mr. President, Madam Vice President, members of the Court, this case transcends legal technicalities. UNRWA's collapse would not only doom millions of Palestinians, it would shatter the credibility of the UN system. Therefore, the Russian Federation respectfully submits the following. First, in our opinion, the Court has jurisdiction to give the advisory opinion requested by the General Assembly. Second, we believe that there are no compelling reasons for the Court to exercise its discretion not to consider the question posed by the General Assembly. Third, Israel, as the occupying power, has the obligation not to impede the Palestinian people from exercising its right to self-determination. Fourth, as the occupying power, Israel is obliged under IHL to ensure and facilitate the unhindered provision of humanitarian aid and assistance to the Palestinian population. Fifth, Due to the unique role of UNRWA in the occupied Palestinian territory, Israeli laws on the prohibition of the agency's activities violate IHL norms and principles. Implementation of these laws will undoubtedly worsen the humanitarian situation for Palestinian population and significantly hinder the realization of the Palestinian people's right to self-determination. And sixth, by passing laws on UNRWA, Israel unilaterally deprives UNRWA of its privileges and immunities, which is a violation of the United Nations Charter and the Convention on Privileges and Immunities of the United Nations of 1946. Mr. President, Madam Vice President, members of the Court, let this Court's opinion be a beacon of hope, a reaffirmation that international law and not the so-called rules-based order governs actions of states and international organizations. Thank you for your attention.
I thank the representative of the Russian Federation for his presentation. J'invite à présent la délégation suivante.
I now invite the following delegation, that of France, to take the floor. And I would like to call Mr. Diego Colas to the podium. You have the floor, sir.
Merci, Monsieur le Président.
Thank you, Mr. President. Mr. President, France would like, first of all, to congratulate you on your election to the presidency of this court. Mr. President, members of the court, my presence before you forms part of the continuing efforts made by my country in order to put an end to the dire humanitarian situation in the Gaza Strip and more generally throughout the occupied Palestinian territory. France deplores the considerable difficulties in accessing reliable information owing to the serious attacks against an increasing number of journalists. That being so, the information which Dutch reaches from Gaza is alarming. On the 24th of April, according to the figures of the Gaza Health Ministry, the human toll of the war amounted to over 51,300 deaths and 117,000 wounded. We must also mention the total interruption of humanitarian aid since the 2nd of March, the depletion of essential items, including food stocks, as well as the violent military operations carried out, many of which affect civilians and humanitarian workers. With regard to humanitarian workers, 418 of them have been killed since October 2023, including 290 personnel from the UN Relief and Works Agency for the Palestinian Refugees in the Near East, UNRWA, or the agency. In response to this situation, that France will never cease to condemn, our position will remain firm and unwavering. Humanitarian aid must reach Gaza at scale. Restrictions to its access must be lifted without delay. All the crossing points must be open, and the work of humanitarian organizations must be facilitated and their personnel protected in compliance with international law. It is against this backdrop of emergency that the present proceeding take place, and which will enable the court to clarify Israel's obligations in relation to the humanitarian presence and activities in the occupied Palestinian territory, and in relation to it in support of the right of the Palestinian people to self-determination. The question put to the court calls for 4 introductory remarks. First of all, it deals with Israel's obligations. It will therefore fall to the court to precisely identify these obligations and the conditions of their observance. The question does not explicitly mention, as was the case for other requests for opinion, the legal consequences of a given behaviour. However, the General Assembly, which requested the opinion and states, will have to draw all the relevant consequences from it. Secondly, the question put refers to the activities of other international organizations. Given the essential role of non-governmental organizations such as Médecins du Monde or Action contre la faim in the occupied Palestinian territory. France considers that their activities must also be taken into account in the present proceeding. However, in the time allocated and in view of the factual circumstances which gave rise to the sitting of the court, my statement will chiefly deal with the presence and activities of UNRWA. Thirdly, because of the expression in relation to, the territorial scope of the question is not limited to the occupied Palestinian territory alone. This wording indeed invites the court to examine the international obligations that Israel must honour on its own territory insofar as their fulfilment is likely to have consequences throughout the occupied Palestinian territory. Finally, France has constantly recalled the importance of complying with the right to self-determination of the Palestinian people. The only chance for it to be exercised, according to France, is a two-state solution, the only solution capable of guaranteeing peace and security in the long term for Israelis and Palestinians. As my country has already underlined, supplying humanitarian aid and development aid will allow for the necessary conditions for the Palestinian people in the long run to be able to exercise its right to self-determination. This aid, therefore, is part and parcel of the exercise of the right for Palestinians for their self-determination. Mr. President, members of the court, in light of these introductory remarks, my argument will successively describe Israel's obligations which stem from its quality as a member state of the United Nations, and then those stemming from its quality of occupying power in the occupied Palestinian territory. It is important to underline that these obligations are not mutually exclusive. On the contrary, they are simultaneously applicable and complement each other. With regard to the obligations arising from United Nations law, I will begin by addressing the general obligations of Israel in relation to the presence and activities of UNRWA in the occupied Palestinian territory and in relation to it, and then more specifically, the privileges, immunities and facilities owed to the agency as a UN organization. First of all, it should be recalled that as for any subsidiary body of the General Assembly of the United Nations, the presence and activities of UNRWA on a given territory are subject to the consent of the parties concerned. Israel and UNRWA have concluded several agreements, including an agreement concerning assistance to Palestinian refugees, which entered into force on the 14th of June 1967, which I will hereafter call the 1967 agreement. This agreement governs the activities of UNRWA in the occupied Palestinian territory, but also activities in relation to it. Some of its provisions indeed refer to the entry of vehicles and personnel of the agency into Israel. The Palestinian Authority has also reached a number of agreements with UNRWA, including an agreement relating to the location of its headquarters in the West Bank and in the Gaza Strip, signed in Ramallah on the 5th of July 1996. On the 28th of October 2024, Knesset adopted two laws aiming at prohibiting the activities of the agency in Israel and through a questionable extension of its domestic law throughout the occupied Palestinian territory. This legislation, amongst others, has given rise to a notification addressed to UNRWA on the 3rd of November 2024, in which Israel deems it has terminated the 1967 agreement. In France's view, the general principle of the consent of the parties concerned by UNRWA's activities must apply in combination with Israel's other international obligations in the occupied Palestinian territory on the one hand and on its own territory on the other hand. I'll deal with both of these aspects successively because the combination is not identical in both situations. First of all, in the occupied Palestinian territory. As a member of the United Nations, Israel's margin of appreciation in banning UNRWA's activities are, first of all, qualified by its general obligation to cooperate in good faith with the UN. This obligation in particular stems from Article 2, Paragraph 5 of the Charter, which provides that the members shall give the United Nations every assistance in any action it takes in accordance with the present Charter. As underlined in the chapeau, the implementation of this provision is a prerequisite for the achievement of the aims of the United Nations laid down in Article 1 of the Charter. In this connection, it should be recalled that the UN's objective, inter alia, is that of achieving international cooperation in solving international problems of a humanitarian character. The Court has long held a broad interpretation of the duty of assistance of Member States by applying it also to the actions of the General Assembly, although there is no suggestion that the legal consequence of this duty is to confer a binding force on its recommendations. Furthermore, Israel's obligation to cooperate with the UN in the specific framework of humanitarian assistance in Gaza has been recalled on several occasions by the United Nations bodies. For example, in its order indicating provisional measures of the 28th of March 2024, which is still producing effects to this day, your court ordered Israel to take all necessary and effective measures to ensure without delay, in full cooperation with the United Nations, the unhindered provisions at scale by all concerned of urgently needed basic services. Israel, therefore, is under an obligation to provide full assistance to the action of the agency in the occupied Palestinian territory, which implies, as a minimum, the obligation not to impede its activities. Turning now to the territory of Israel proper. The obligations of Israel vis-à-vis UNRWA in the occupied Palestinian territory must be distinguished from those concerning the presence of the agency on the Israeli territory as such. In its advisory opinion relating to the headquarters of the WHO in Egypt, the court has recognized the sovereign power of decision of a state when it comes to the presence of a UN agency on its territory. The withdrawal of consent of a state to this presence stems from the same sovereign power of decision. Having said this, this power is governed by the obligations owed to the UN by a member state in the case of a denunciation of the agreement relating to the presence of a UN agency on its territory. These obligations have been described in detail by the court in its aforementioned opinion. And this opinion is may very well be transposed to the instant case, in part because the 1976 agreement says nothing of the modalities for denouncing it. Pursuant to these obligations, Israel and UNRWA must first of all negotiate in good faith the conditions for transferring the agency's activities outside the Israeli territory. Israel must also allow the agency a reasonable notice period to prepare for its departure, and finally grant it and grant its personnel the privileges, immunities and facilities necessary for a smooth transitional period. Furthermore, the exercise by Israel of its power of withdrawing its consent to the presence of UNRWA on its own territory means that it must take into account the consequences of such a decision on the occupied Palestinian territory. This decision indeed has consequences in relation to the occupied Palestinian territory within the meaning of the question put to the court. Many of UNRWA's activities in the occupied Palestinian territory are conditional on facilities or authorizations issued by Israel on its own territory, including for any transit to or from the occupied Palestinian territory. Doing away with these facilities would concretely and lastingly impede physical access to the occupied Palestinian territory and therefore impede UNRWA's ability to operate there. Such consequences would obviously be incompatible with Israel's obligation not to impede the actions of the agency on the occupied Palestinian territory, as previously discussed. This obligation must therefore equally be considered as qualifying the sovereign power of decision of Israel in relation to the presence and activities of UNRWA on its territory.
I would now like to turn to the obligation to respect the privileges and immunities and the facilities of UNRWA. Article 105 of the UN Charter and the Convention on the Privileges and Immunities of the United Nations, which I will call General Convention, specifies the privileges, immunities and facilities that Israel must afford to the United Nations and its staff. It should be noted that the scope of the convention, this General Convention, was explicitly extended to the occupied Palestinian territory by the 1967 agreement. However, even if this agreement were considered to have been duly denounced, the General Convention would still remain applicable to UNRWA both in Israel and in the occupied Palestinian territory. Indeed, if Article 105 of the Charter refers to the territory of each of its members, the provisions of the General Convention, commonly regarded as an amplification of Article 105, are drafted in particularly open terms. They refer, for example, to UN property and assets wherever located and by whomsoever held. This is in Section 3. The object and purpose of the General Convention is to protect the assets of and the agents of UN with a view to enabling them to exercise their missions for which these members have been mandated. Therefore, it would be indeed paradoxical and even contrary to the object and the purpose of the Convention to deprive the organization of any form of protection on the grounds that it is acting in occupied territory, whereas it is a territory over which it has a particular responsibility itself. Consequently, Israel is obliged to apply the General Convention in the territory that it occupies, even in the absence of a special agreement to that effect. I will now address successively Israel's obligations under international humanitarian law and then under international human rights law. As far as international humanitarian law is concerned, France underscores to begin with that Israel, just like other states, has the obligation to respect and ensure respect of the Geneva Conventions under all circumstances. Furthermore, as the Court recalled in its opinion of July 2024, neither the duration nor the unlawfulness of Israel's occupation in Palestine results in releasing the occupying power from its obligation in this respect. So in this context, I will limit my comments to detailing two obligations. The first of these obligations is to ensure and to facilitate unhindered supply of basic necessities that are essential to the survival of the civilian population. This obligation originates in Article 59 of the Fourth Geneva Convention, to which Israel is a party, and which applies to the whole of the occupied Palestinian territory, including Gaza, as your court recalled in its opinion last July. The question of the application of this provision arises with extreme gravity at the very moment when the current hearings are taking place. In Gaza, the entry of trucks delivering humanitarian assistance has been totally suspended since the 2nd of March. International organizations that are still present are warning us about the depletion of food stocks and multiple shortages of medicine. It should be noted that even in the West Bank, the increasing number of controls is hampering the intervention of human organizations on a daily basis. Article 59 imposes on the occupying power two obligations that it cannot be released from if it is established that all or part of the population of the occupied territory is inadequately supplied. In this case, the occupying power must, on the one hand, accept humanitarian assistance, because this is a performance obligation. Therefore, the occupying power must not refuse any humanitarian assistance. On the other hand, the occupying power shall facilitate the relief schemes by all the means at its disposal. And by virtue of this obligation of conduct, the occupying power must, in good faith, use all means available to facilitate the delivery of aid that it has accepted. Article 59 is worded in such a way that it covers both collective relief provided by states and the aid provided by impartial humanitarian organizations. However, it does not provide any restrictive list of relevant organizations in this context. In principle, an occupying power therefore has a margin of discretion in the choice of organizations capable of providing the necessary aid. In practice, however, the occupying power is obliged to take into account the specific circumstances of the territories that it occupies in order to authorize and to facilitate the activities of adequate humanitarian organizations, that is to say, those that are genuinely capable of providing sufficient aid to supply the local population. Finally, it should be emphasized that Article 59 contains a safeguard clause allowing notably the occupying power to search the consignments and to regulate their passage according to prescribed times and routes. While controls may be justified under this clause, France would like to recall that they cannot lead to preventing humanitarian assistance because that would render Article 59 devoid of substance. In the present case, it should be borne in mind that UNRWA is indeed the main provider of humanitarian assistance and essential services in the occupied Palestinian territory. Furthermore, France notes that to benefit from these provisions, UNRWA must be an impartial body within the meaning of Article 59. And in this context, France has noted the conclusions of the Colonna report on UNRWA's adherence to the principle of neutrality. It stresses that the agency is committed to implementing and continuing to apply a zero-tolerance policy in this regard. These circumstances, coupled with the catastrophic current situation, reduces significantly Israel's margins of discretion in executing its obligation under Article 59. Indeed, in the absence of other actors with sufficient capacity to provide adequate supplies effectively to the population, Israel is obliged, as occupying power, as long as the situation persists, to authorize and facilitate UNRWA's relief schemes in the occupied Palestinian territory. Israel's second obligation as an occupying power is to protect humanitarian workers. Indeed, for humanitarian aid to be effectively delivered to civilians, the safety of staff working for the organizations providing that aid must be ensured on the ground. And parties to the conflict must conduct hostilities with this protection in mind. In this respect, the obligation to protect humanitarian workers can be considered as a corollary of the right of the civilian population to be rescued. Under customary international law, the rule according to which humanitarian relief personnel must be respected and protected is also regularly recalled by the Security Council. This reminder seems all the more necessary given that, according to the UN Office for the Coordination of Humanitarian Affairs, on the 22nd of April 2025, at least 418 humanitarian workers have been killed in the Gaza Strip since the outbreak of the war in October 2023. In this context, France reiterates its condemnation of Israeli firing on ambulances that killed rescue workers, 15 rescue workers from the Palestinian Red Crescent, the Civil Defense and UNRWA in Gaza on 23rd of March 2025. I would now like to turn to Israel's obligation to respect international human rights law in the occupied Palestinian territory. As the court has had the occasion to indicate, Israel's obligations derive, among others, from the two covenants of 1966 as well as from the UN Convention on the Rights of the Child. Moreover, the court has already recalled that the protection offered by human rights conventions does not cease in case of armed conflict or of occupation. Indeed, Israel's obligation to provide humanitarian access under international humanitarian law is supplemented by various other obligations under international human rights law. And in view of the serious and imminent risk of famine that Palestinian civilians in Gaza are facing, I would also like to emphasize the right to health and the right to adequate food. In accordance with Article 2 of Paragraph 1 of ICESCR, each state party undertakes, individually and through international assistance and cooperation, with a view to achieving progressively the full realization of the rights recognized in the present covenant by all appropriate means. Consequently, if human assistance is in a given situation indispensable to the realization of the two aforementioned rights, a state must consider this aid as a means that is appropriate to their realization within the meaning of this provision. In view of the untenable situation in which the Palestinian civilian population finds itself, there can be no doubt that humanitarian assistance can be qualified as a measure that is conducive to Israel's implementation of its obligation under ICESCR. Moreover, since such aid would be essential to the enjoyment by the Palestinians of their fundamental rights, Israel could not restrict access to it without violating the aforementioned obligation. Mr. President, members of the court, it follows from all these elements that Israel is under the obligation, given the critical humanitarian situation in the Gaza Strip, it is under the obligation to authorize and to facilitate the presence and activities of humanitarian actors there, in particular those of UNRWA. To conclude, France reiterates its appeal to the Israeli authorities to put an end to the dramatic humanitarian situation in Gaza, and to this end it calls on Israel to cooperate with its international partners, including the United Nations, to ensure, as a matter of urgency, access and security for humanitarian operations in the Gaza Strip and the whole of the occupied territory. Thank you very much for your attention.
Je remercie le représentant de la France.
I would like to thank the representative of France for his presentation.
Next delegation to take the floor, the court will observe a coffee break of 15 minutes. The hearing is suspended. I'll now invite the next participating delegation, Hungary, to address the court. And I give the floor to Ambassador Ilgu Kutis.
Mr. President, Madam Vice President, distinguished members of the court, it is an honor to appear before you today on behalf of Hungary concerning the case obligations of Israel in relation to the presence and activities of the United Nations, other international organizations, and third states in and in relation to the occupied Palestinian territory. Allow us to take this opportunity to express Hungary's commitment to the principal judicial forum of the United Nations that plays a fundamental role in the field of international law. During its 80 years long history, the court has contributed significantly to the strengthening of the rules-based international order. The increasing number of states submitting their disputes to the court's adjudication and the unprecedented workload of the court reflects the trust of states both in the court's mandate and in the quality of its work. It is of great importance to maintain the confidence in the work of the court and to abstain from proceedings that may erode that confidence and may create a situation where the court becomes an actor in an ongoing conflict. The government of Hungary recognizes the importance of the numerous proceedings for an advisory opinion and the potential impact that they have on the prospects for peace and stability in the Middle East. When discussing the issue of the advisory opinion proceedings and the question posed to the court within the request at hand, one must reflect upon the broader political context, taking into account the dimensions of the Israeli-Palestinian conflict. Although the current proceeding aims to address specific issues of international law obligations with regards to a member state of the United Nations, the pattern of politicization of international judicial fora cannot be disregarded when examining this case before the esteemed court. Hungary recalls that in 2004, this esteemed court clearly stated in its advisory opinion concerning the construction of a wall that the resolution of the Israeli-Palestinian conflict can only be achieved through direct negotiations between the parties on the basis of international law and through the implementation of the relevant Security Council resolutions. Since 2004, this original approach has not changed, although numerous aspects of the political context have shifted. The horrendous terrorist attack conducted against Israel by Hamas on 7 October 2023 was a turning point. Hungary strongly condemns these horrific terrorist attacks and calls for the immediate and unconditional release of all hostages. Since then, Israel has been fighting the terrorist organization Hamas with the aim to prevent such monstrous terrorist attacks ever happening again. The evil of terrorists is well shown by the fact that they use innocent civilians as well as education and healthcare facilities, including those associated with the United Nations, as shields. Sparing the lives of both Israeli and Palestinian civilians is of the utmost importance now as well as in the future, with a sustainable peace free of terror. The terrorist attack of 7 October 2023 can also be considered a turning point with regards to the intensification of activities in the field of international law in relation to the conflict, including those of the esteemed court. We welcome that the esteemed court has called several times for the immediate and unconditional release of the hostages held by Hamas, and underlined that all parties to the conflict must abide by international humanitarian law and international human rights law. We must also note that the proceeding brought before this esteemed court may directly contribute to the escalation of the conflict. We are of the view that the present and the former requests for rendering an advisory opinion as well as the procedure initiated by the Republic of South Africa against the State of Israel, may be considered as an interference in an ongoing conflict that does not contribute to the de-escalation and an eventual settlement. It is our conviction that politicization of the court and, in fact, utilization of the court creates new dividing lines and continues to fuel tensions. Hungary has also welcomed the ceasefire agreements related to the hostilities. Unfortunately, the latest ceasefire agreement collapsed in March of this year, leading to an all-consuming high-level conflict. In view of this, Hungary stresses the need for a new ceasefire agreement in order to secure the immediate and unconditional release of all hostages and to achieve a lasting resolution of the conflict through negotiations between the parties concerned. Bearing in mind this broader context, let me now turn to addressing the three main issues that Hungary considers the most important to highlight, as we have also done so in our written statement. Hungary wishes to present issues related to the jurisdiction of the court, arguing that the court should use its discretionary power to decline to give an opinion. With regards to the questions posed to the esteemed court, we wish to present arguments based on the established legal framework regarding the agreements on privileges and immunities of the United Nations, with a particular focus on UNRWA. And finally, Hungary wishes to reiterate its position concerning the context of the present advisory procedure. Mr. President, distinguished members of the court, with regard to the first issue, Hungary duly submits that Article 96 of the Charter of the United Nations establishes the possibility for certain organs of the United Nations to initiate advisory proceedings. In addition, it is necessary to take into account paragraph 1 of Article 65 of the Statute of the Court, according to which the Court may give an advisory opinion on any legal question. The Court was unanimously convinced that Article 65 means that the Court has a discretionary power to decline to give an advisory opinion, even if the conditions of jurisdiction are met. The Court has to take into consideration several aspects when elaborating on the question of whether to use its discretionary power to refuse to give an opinion. As regards the limits of the discretionary power, the Court's jurisprudence is consistent in this regard. Only compelling reasons should lead the Court to refuse its opinion. With regard to the compelling reasons, in the present case, we are of the view that several compelling reasons should be taken into account that individually, as well as cumulatively, may require the Court to refrain from issuing an advisory opinion to the present question. First, in 2024, in another advisory opinion proceeding on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem, the Court has already given its opinion with regards to the applicable rules and principles of international law, and expanded on its understanding of Israel's specific obligations. It cannot be disregarded that the advisory opinion of the Court was given on 19 July 2024, merely 4 months before the request of the present advisory opinion was adopted by the General Assembly of the United Nations. Second, a contentious proceeding is currently pending before the Court that also touches upon the specific obligations of Israel. Giving the advisory opinion might essentially prejudge elements relevant to the case brought against Israel by the Republic of South Africa, thus gravely undermining the integrity of the Court's judicial function. We recall the existing precedent for rejecting a request for an advisory opinion based on compelling reasons. The predecessor of the Court, the Permanent Court of International Justice, declined to issue an advisory opinion on the status of Eastern Karelia, a decision that gave rise to the Eastern Karelia principle. This decision, and principle has never been overruled. We know that the court in its subsequent decisions has always taken due care to demonstrate the factual differences from the Eastern Karelia case when considering the exercise of its jurisdiction. This must lead us to the conclusion that the legal criteria set out in that decision remain authoritative. In the decision not to render an advisory opinion, it was stated, "The question put to the PCIJ was directly related to the main point of the dispute actually pending between two states, so that answering the question would be substantially equivalent to deciding the dispute between the parties." The situation in the present case is strikingly similar, as an advisory opinion rendered will unquestionably influence and thus might potentially prejudge determinations to be made in the parallel contentious proceeding. Third, the question submitted to the court has been formulated in a manner that is blatantly prejudicial and one-sided. The question posed by the request is indeed so targeted at Israel that it proceeds on the assumption that Israel has failed to meet its obligations under international law. Without any regard to Israel's legitimate security interests and concerns, or to the obligations of the United Nations and third parties in relation to the very subject matter of the question. Replying to the question would inherently entail an affirmation of the statements in the request. Last but not least, we emphasize that the request would require the court to undertake significant factual investigations and make concrete findings on disputed and dynamic matters, which cannot properly be pursued in the framework of advisory proceedings. However, the advisory proceedings of the court are inherently ill-suited for the fact-specific analysis. Disregarding such analysis may further hinder the legitimacy of the court. Thus, the limitations of advisory proceedings should be duly taken into account by the court when deciding to exercise its jurisdiction. Therefore, we reaffirm that an advisory opinion in the present case would be contrary to the common interpretation of compelling reasons and therefore could have a negative impact on the perceived legitimacy of the court. Mr. President, distinguished members of the court, without prejudice to our firm position that the court should decline to give the advisory opinion, we now turn to the second major issue, the legal framework of the United Nations' presence in member states and specificities of UNRWA. Members of the United Nations have assumed voluntarily obligations to enable the UN, its specialized agencies, funds, and subsidiary bodies to fulfill its principal purpose as enshrined in the Charter of the United Nations, namely the maintenance of international peace and security and the peaceful settlement of disputes. The obligations enabling the fulfillment of these peaceful purposes are, as such, neither absolute nor unqualified. The obligations that members of the UN have taken upon themselves are in the Charter of the United Nations, as well as the 1946 Convention on Privileges and Immunities of the United Nations. We have to underline the necessity of the joint interpretation of numerous articles of the UN Charter and provisions of the 1946 Convention. Article 1 of the Charter states clearly the purposes of the organization, and the introductory sentence of Article 2 makes a clear link to the first article. In it, the introductory sentence of Article 2, a distinction is made clearly indicating that obligations arising from Article 1 and 2 are also prescribed for the organization itself. Obligations arising from Article 2 thus have to be interpreted consistently taking into account the actions of the UN, its specialized agencies and subsidiary bodies as well. Thus when paragraph 5 of Article 2 of the Charter stipulates that all members shall give the United Nations every assistance in any action it takes in accordance with the present Charter, it is clear that a limitation to this obligation is included. The organization is obliged to take actions in accordance with the Charter. Thus, if actions of the organization were to be found contrary to the Charter, the member in question cannot be expected to give the assistance required by the said article. Article 105 of the Charter provides that the organization shall enjoy in the territory of each of its members such privileges and immunities as are necessary for the fulfillment of its purposes. This provision is also clearly linked to Article 1 and 2 of the Charter that contain that the fulfillment of the purposes of the organization must be in accordance with the Charter. Article 105 also sets a clear limitation in terms of the extent of the privileges and immunities, making it clear that there is a functional approach to be applied. The obligation of impartiality in the execution of the functions of the organization can be derived from Articles 100 and 101 of the Charter. This obligation is further codified in the staff regulations and rules of the United Nations, including in its core values. Moreover, the duty to act impartially constitutes a fundamental principle of the status of international civil servants. It must be noted that the 1946 Convention has a specific functional approach as laid down in the preamble of Articles 4 and 5 of the Convention. As is customary in international law, privileges and immunities are intended to enable the efficient functioning of actors of international law, in this case the United Nations. The joint interpretation of articles of the Charter, the 1946 Convention, and the staff regulations and staff rules, including provisional staff rules of the United Nations, is necessary. It can thus be concluded that obligations exist not only for the member states, but the organization as well. The UN shall act in accordance with the purposes of the Charter, and this creates a limitation to the privileges and immunities provided to the organization in carrying out its functions. As Resolution 79/232 is specifically focused on UNRWA, observations must be made with regards to this subsidiary body established by the UN General Assembly. Resolution 302 of 1949 did not specifically outline UNRWA's privileges and immunities. It simply called on states to grant the same privileges and immunities as for its predecessor. This clearly means that in order to be able to implement the requirements of the Charter and the 1946 Convention, additional agreements with the host states needed to be concluded. This has in fact become the practice concerning other host states of UNRWA. With regards to Israel, an exchange of letters was conducted on 14 June 1967 between Israel and UNRWA, the so-called Comey-Michel-Moore Agreement. The exchange of letters specifically states that the Israel government will facilitate the task of UNRWA to the best of its ability, subject only to regulations or arrangements which may be necessitated by considerations of military security. Thus, taking into account the legitimate security concerns of Israel, the exchange of letters also makes specific reference to the 1946 Convention. UNRWA's failure to maintain neutrality and the involvement of UNRWA staff members in acts of terror undermine its status as a legitimate aid organization. UNRWA's tie to terrorism has become an established fact, particularly following the revelations regarding the involvement of UNRWA employees in the 7 October 2023 attacks. Following allegations that at least 19 UNRWA employees participated in the attacks, the United Nations itself also responded, thus acknowledging the necessity to react to the presented evidence of this involvement. The involvement of UNRWA staff members in acts of terror constitutes a serious breach of the principle of impartiality and the lack of acting in accordance with the principles enshrined in the UN Charter. Furthermore, it is a well-established international norm reflected in multiple conventions and UN resolutions, such as Resolution 1373 of 2001, that organizations are prohibited from providing assistance to terrorist organizations. These facts constitute a ground for the abrogation from the Comey-Mission-Moore Agreement and justify the limitations to the privileges and immunities granted to UNRWA as a subsidiary body of the UN General Assembly. Mr. President, distinguished members of the Court, without prejudice to our firm position that the Court should decline to give the advisory opinion, I now turn to our third and final quarrel. Further elaborating on the introductory remarks, we would like to refer to the broader context in which the request for the advisory opinion was made. It is important to note that Israel withdrew its military presence from the Gaza Strip in 2005. It is the terrorist organization Hamas, which violently took power in 2007, that has been governing the territory, including by way of control over the local economy, policing and internal security, welfare services, tax collection, education, and the media. This request for an advisory opinion cannot be separated from the ongoing conflict, and regrettably, it may only be interpreted as an additional avenue within the conflict. There is a realistic fear that the Court itself is being used as a battleground. As explained above, the involvement of a subsidiary body of the United Nations General Assembly through its staff members in actual acts of terrorism is precisely the reason why there is a need to consider the abrogation of privileges and immunities. Unfortunately, the esteemed Court will implicate itself in matters that unduly politicize the esteemed institution of an otherwise strictly judicial character. Our concern is not in vain. The advisory opinion of 19 July 2024 did in fact become part of the already heated political debate. We firmly believe that the peace and long-term solution of the Israeli-Palestinian conflict can only be achieved through enabling meaningful dialogue between the parties concerned. The proceedings before the Court, due to their highly politicized and divisive nature, further escalate the tensions between the parties. In conclusion, Hungary has in the present statement put forward 4 compelling reasons why the Court should not render the advisory opinion, which has been requested of it. Without prejudice to this request, Hungary has also put forward arguments with regards to the broader political context, which must be taken into account, as well as the legal framework of privileges and immunities of the United Nations and UNRWA. Therefore, Hungary respectfully requests the Court to decline providing an advisory opinion. Mr. President, members of the Court, this concludes my presentation today. I thank you for your kind attention.
I thank the representative of Hungary for his presentation. I now invite the delegation of Indonesia to address the Court, and I call upon His Excellency Minister of Foreign Affairs, Sugiono, to take the floor.
Mr. President, Madam Vice President, honorable judges of the Court. It is a great honor and privilege for me to appear before you honorable judges on behalf of the Republic of Indonesia to defend justice and humanity of the people of Palestine. Indonesia is and will always stand with the people of Palestine to attain their independence. Our commitment to and profound bond with the Palestinian people is rooted in humanity, that it is their inalienable rights to live in peace in their very own homeland. Indonesia attaches its utmost importance to the rule of international law and has a strong confidence that the decision of this distinguished court will guide the General Assembly and its member states in delivering justice to the persecuted and oppressed Palestinian people. Let me stress that while many countries, including Indonesia, clearly express that no country should be above the law, Israel has consistently imposed its nefarious policies and measures in the occupied Palestine territory in utter disrespect to the international law. Israel's continuing unlawful presence in the occupied Palestinian territory and its coercive environment created had made it impossible for the Palestinian people to exercise its basic rights as a nation, the right to self-determination. Against this backdrop, Indonesia assumes its moral duty to furnish information on the issues brought by the General Assembly to this court. I will firstly address the issue of jurisdiction, followed by the merit of the case on Israel's obligations as a UN member and as the occupying power. Honorable judges, on the jurisdiction, Indonesia asserts that this court has jurisdiction to provide its opinion requested by the General Assembly under Article 96, Paragraph 1 of the UN Charter and Article 65 of the Court Statute, and that there are no grounds for declining to do so. The question raised to this court is a legal question and within the scope of activities of the General Assembly. And this is consistent with the opinion of the court, such as in the Chagos advisory opinion, which stated that the request for an advisory opinion from the Assembly seeking to examine a situation by referencing to international law is a legal question. The present request fits into that requirement, as the chapeau to the present question makes it unequivocal for scrutinizing Israel's obligation by reference to international law. There should be no doubt that this court has jurisdiction to deliberate over the present request for advisory opinion. Mr. President, on the merit of the case, Indonesia submits that Israel, as a member of the UN, bears a general obligation to adhere to its commitments to accept and perform obligations stipulated by the UN Charter in a good faith. Israel had accepted such obligations through its declaration accepting obligations under the Charter made on 29 November 1948. And Israel's acceptance was a crucial undertaking pursuant to Article 4, Paragraph 1 of the Charter to be admitted to the UN membership. In its declaration, Israel states that, and I quote, "The State of Israel unreservedly accepts the obligations of the United Nations Charter and undertakes to honor them from the day when it becomes a member of the United Nations." End quote. The term used in the declaration is unreserved, and I do not need to enlighten this court on the significance of this term. Referring to this court's opinion on the reparation for injuries, Israel's acceptance of the obligation of the Charter must be strictly observed. In this regard, Israel's ongoing violation of and its failure to fulfill its obligation under international laws have raised the question of its suitability to be called a peace-loving state, which is a prerequisite of the UN membership as prescribed in Article 4, Paragraph 1 of the Charter. I shall explain further that Israel's general obligations under the Charter encompasses obligations to respect the presence of the UN, to facilitate and give every assistance to the UN, as well as to carry out the decisions of the UN Security Council, the judgments and the decisions of this court. By virtue of Security Council's resolutions, Israel also owes those obligations toward other international organizations and third states. Honorable judges, I shall emphasize that Israel is under the obligation to respect the presence of the UN, including UNRWA as the UN body responsible for discharging UN's humanitarian assistance. This obligation is provided for in Article 105 of the UN Charter and have been further elaborated in the 2 UN conventions on the privileges and immunities of the UN, both of which Israel is a state party. These conventions emphasize that the scope of Israel's obligations is relevant to the present request in relation to the premises, property, assets, and funds of the United Nations, to the archives and documents of the UN, and to the experts and officials on missions of the UN. As this court noted in its advisory opinion regarding reparation of injuries, these privileges and immunities are essential for ensuring the fulfillment of the UN's functions independently and effectively. This is particularly relevant in the present context, where the UN has to properly discharge its humanitarian functions in the occupied Palestine territory. Having said the above, I wish to submit that Israel's conduct, including its enactment of laws targeting the UNRWA's operation, contradicts Israel's obligations to respect the presence of the UN. Honorable judges, on the obligation of Israel to facilitate and provide every assistance to the UN, as well as other international organizations and third states, I wish to point out several obligations that were imposed to Israel by this court in its various order of provisional measures in the case of South Africa versus Israel. Those, among others, are obligation to take all necessary and effective measures to ensure the unhindered provision of the urgently needed basic services and humanitarian assistance, to immediately halt military offensive and any other action which may inflict on Palestinian people, and to maintain the opening of the Rafah crossing for unhindered provision of the urgently needed basic services and humanitarian assistance. As the matter of law, those obligations imposed by the court have a binding effect upon Israel by virtue of Article 94, Paragraph 1 of the UN Charter. This binding effect has also been affirmed by this court in its 2001 judgment of the La Grange case. I wish to stress that as a failure to perform the above-mentioned obligations would result in the suffering of innocent civilians, particularly the vulnerable groups, such as the elderly, women and children, and Israel's non-fulfillment of those obligations constitutes a violation of human rights obligations. Article 4 of the International Covenant on Civil and Political Rights, or ICCPR, establishes that human rights protection does not stop during armed conflict. And as this court determined in its 2004 Wall Advisory Opinion, both international humanitarian law and international human rights law are applicable in times of armed conflict. Having pointed out all the above, Indonesia emphasizes that the issue we deliberated is not a matter of political exigency, nor it merely a moral inquiry, but one that is grounded in international law, upon which Israel is legally bound to discharge its obligations in good faith and without reservation. Honorable judges, I would like now to move to Indonesia's submission regarding Israel's obligation as an occupying power. Israel's status as an occupying power in the Palestinian territory, including Gaza, is a matter beyond dispute. It has been affirmed by this court and by countless resolutions of the UN Security Council and the UN General Assembly. This determination has also been made by the court's previous advisory opinion of 9 July 2004 and 19 July 2024. As an occupying power, Israel's legal obligations extend beyond the general duties owed by all states under international law. The Fourth Geneva Convention governs the protection of civilians during times of armed conflict and occupation, and it places specific duties on Israel with respect to the humanitarian needs of the Palestinian population in the OPT. The language of this convention is clear, that Israel is bound to uphold at all times and under all circumstances those obligations. It is important to highlight that those obligations are rooted in customary international law and have been consistently reinforced by international legal precedent. With regard to this Fourth Geneva Convention, Indonesia respectfully submits that Israel is duty-bound at least to first ensure the provision of basic supplies. Second, to accept and facilitate relief schemes. Third, maintain medical services and protect humanitarian personnel. Fourth, not conduct any forms of collective punishment. And fifth, not forcibly transfer and deport civilian population. I will address those obligations in turn. First, Indonesia submits that Israel is bound to comply with its obligations to ensure basic supplies as provided for under Articles 50 and 55 of the Fourth Geneva Convention. In particular, Israel must ensure that the civilian population in the OPT is provided with essential supplies, including food, medical care, and other necessary services, and this obligation goes further to underscore the positive duty to maintain special protections for vulnerable groups, including children under 15, expectant mothers, and mothers of young children. Israel cannot ignore these responsibilities as they are unequivocal and opposable to Israel as the occupying power. Failure to meet this obligation will have grave consequences for the civilian population and constitute a breach of Israel's duties under international law. Second, Israel is obliged to agree on relief schemes, especially to fulfill basic necessities as provided under Articles 38, 59, and 62 of the Fourth Geneva Convention. This obligation extends to Israel as the occupying power to cooperate with international humanitarian agencies to establish relief schemes for the provision of food, medical care, and other essential services. This obligation becomes even more crucial as the civilian population is inadequately supplied. The spirit of these provisions is clear. Humanitarian aid must be facilitated by the occupying power, not obstructed. It becomes evidently clear that Israel does not fulfill this obligation. Moreover, it played a pivotal part in the unfolding of the biggest humanitarian catastrophe of this decade, if not this century. The entire Palestinian territory has been living with persistently low living standards, being denied access to water, food, and energy. Third, the Geneva Conventions also impose strict obligations on Israel to protect medical facilities, healthcare personnel, and the provision of healthcare services under Articles 14, 17, 18, 20, 21, 30, 47, 53, 56, and 63 of the Fourth Geneva Convention. These include ensuring that hospitals are not attacked and that medical personnel can carry out their work without interference. These duties are not optional. At this juncture, Israel has clearly failed to respect those obligations. Indonesia wishes to highlight the fact that one of these failures was evident in the event of Israel's attack toward the Indonesian hospital in Gaza in 2023. This attack was perpetrated against one of the most critical health infrastructure in Gaza, despite the fact that there were patients being treated. Fourth, Israel is also duty-bound to not perpetrate collective punishment under Article 33 of the Fourth Geneva Convention. Collective punishment is prohibited, and any policy or practice that imposes collective punishment is a violation of these rules. Israel must therefore ensure that any measure taken in the OPT does not punish the civilian population collectively. The legal principle is clear. Individuals should not suffer for the actions of others. However, the reality speaks a horrible truth. The imposition of a total siege by Israel, cutting off electricity, water, food, and medicine, punishes the entire civilian population of Gaza for the actions of a few. Statements by high-ranking Israeli officials that assign collective guilt to an entire nation reinforce the conclusion that such measures are intended to punish civilians indiscriminately. This is not only illegal, but morally indefensible. Fifth, Article 49 of the Fourth Geneva Convention prohibits the transfer or deportation of civilians from the OPT. This provision is designed to protect the integrity of the Palestinian population and to ensure that they are not forcibly displaced from their homes. Any measures relating to evacuations may only occur for imperative military reasons, and even then must be temporary, non-destructive of the civilian population's rights. Israel must respect this obligation and refrain from engaging in any actions that would lead to the unlawful transfer of civilians from the occupied territory. Yet, what we have witnessed in Gaza is the de facto policy of permanent dispossession. Israel is deliberately conducting a policy of forced mass displacement, accompanied by destruction of civilian infrastructure. More than 66% of buildings in Gaza were destroyed, and the requirement to return displaced persons to their homes has been rendered meaningless. Honorable judges, Indonesia would also like to add that Israel's obligations as an occupying power are also grounded in international human rights law, particularly the International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights, of which Israel is a state party. According to these international covenants, Israel is obliged, among others, to allow and facilitate relief schemes of the UN. There are specific obligations to implement this relief scheme, such as the obligation to recognize the right of everyone to an adequate standard of living, which is stipulated under Article 11, Paragraph 1 of ICESCR. The obligation to recognize the right of everyone to the enjoyment of the highest attainable standard of physical and mental health, which is under Article 12, Paragraph 1 of the ICESCR. Furthermore, there are also obligations to respect and ensure the right to liberty and security of person under Article 9, Paragraph 1 of the ICCPR, and the obligation to respect and ensure that persons deprived of their liberty shall be treated with humanity under Article 10, Paragraph 1 of the ICCPR. Honorable judges, finally, I shall also furnish information on the crux of the Palestinian issue, the right to self-determination. The Palestinian right to self-determination is the raison d'etre on why the court should grant the request of the UN General Assembly. The questions posed are central to the fulfillment of the Palestinian right to self-determination, a fundamental principle of modern international law as provided in the UN Charter, as well as the Bandung Conference of 1955. This honorable court has repeatedly and unequivocally stated in the 2004 Wall Opinion, as well as the 2024 Legal Consequences Opinion, that Palestinians have the right to self-determination. This opinion has also been exemplified by a multitude of resolutions of the United Nations. The current reality contradicts all that was envisioned by such right. On the ground, the world has vividly witnessed the systematic destruction of civilian infrastructures and hospitals in Gaza, making life unattainable. This action actively impedes the dispersal of Palestinian people and hinders their rights to determine their very own political, social, economic, and cultural status. In light of these facts, time and again, Indonesia unwaveringly submits to the court that Israel shall be under the obligation to fulfill the Palestinian people the right to self-determination. Indonesia respectfully appeals to the honorable judges that international law must prevail and justice is rightfully delivered. This court opinion will provide much needed guidance to the international community on how to reinforce the primacy of international law to solve the worst man-made humanitarian catastrophe of the century the Palestinian people continue to endure. Thank you.
I thank the representative of Indonesia for his presentation. This concludes this morning's sitting. The oral proceedings will resume this afternoon at 3 p.m. In order for Turkey, the Islamic Republic of Iran, Jordan, Kuwait, and Luxembourg to be heard on the question submitted to the court. The sitting is closed.